Good morning.
Good morning, Wayne.
Good morning. Good morning, Andre. I think we have a couple new people today, so we want to do a mic check if that's okay. Mr. Pukowski?
Good morning. I can hear you.
Sounds good.
Thank you.
Ms. Sheen?
I won't be speaking, but hello.
You sound great, but
Thanks.
thank you for that.
Good morning, Wayne.
Good morning, John. Mr. Pukowski, can I ask you to put in your affiliation in your name?
Sure. Miloš Puchovski.
Puchovski, I'm sorry.
Puchovski, yeah.
What's your affiliation? If I could just add it to the back of your Zoom name.
I'm sorry.
Rename yourself on Zoom, and at the end of your name, you see how we all have EFSB on our
Yes.
on our names. So just whatever your affiliation is.
Oh, okay. So let me see. Rename.
Mr. Bertram, could you do the same as well?
Hear us?
Yep, we can hear you.
Very good.
Okay, so everybody we have here right now is good for sound check. We have about 5 more minutes before we begin. Keep in mind, YouTube, if you hadn't noticed, is already running, so it's a hot mic essentially. So we're not on the record, but the screens are being recorded now. At any rate.
Mr. Presiding Officer, can you hear me?
Yes.
Hi, it's Chris. We have the conference room on hold, it looks like, for the Zoom. Just wanted to see if you saw it.
I don't see it in the panel right now. Wayne has more of a view than I do.
Yep. So because we haven't started the webinar officially, we'll only be able to bring you on when the webinar starts from the attendees list. That's okay.
Nope,
Should be
no
pretty
problem.
quick.
Just wanted to make sure there was no issue. Thank you, sir.
Yep. Thank you. Good morning, Kathy.
Morning.
Okay, about 4 minutes. If anybody has to do anything last minute, now would be the time.
Andre, was there a second witness for same as the Pine Barrens?
There is supposed to be. Let me take a look at the.
Yeah, there's supposed to be a Mr. Hinckley.
Yep.
I was emailing it with him this morning, so I expect him soon.
Okay. Thank you.
Wayne, if you could just be on the lookout just in case he comes in the other. Yep.
Andre, so I think I'm gonna start the webinar in case he's in the attendees list, since we're already on YouTube anyway.
Yeah, that's fine. I'm not gonna go on record until after 10.
Sounds good. Could we do a mic check on the conference room, Mr. Kaplan? You're muted right now. I'll try to ask you to unmute. 30 seconds, right? Sorry, I'll wait.
Perhaps you can also rename yourselves. We're getting BOS Longfellow right now for the conference room.
I'm doing it right now, John.
Okay, thank you.
Interesting. I can hear us now.
A little faint. Andre, I see Mr. Hinckley in the attendees list. I'm promoting him. Mr. Hinckley, could we do a mic check for you?
Good morning, John Hinckley here.
Good morning.
Can you hear us any better?
Alan, how do they sound to you?
Not great, but adequate.
Okay, well, we're gonna get somebody to help and figure out what the issue is.
You sound great.
Because the sound.
now.
You sound okay
sound-
now.
You gotta speak loud, that's the thing for it to. Okay, we have to yell. Is that better?
Yes.
Okay.
Mr. Hinckley, could I ask you to add in your affiliation at the back of your name on Zoom? But just renaming yourself?
Sure. I will try to do that. I don't do a lot of Zoom meetings. I usually use Teams. Is there, can you just give me a pointer as to how to put in my affiliation?
On the top right-hand corner of your image, there's 3 dots. If you press on that.
Got that. Oh, rename.
It is. They can hear us if we go lower, but it's gonna drive me crazy.
Yeah, I don't think it's correlated.
So Andre, we have all of the Save the Pine Barren witnesses.
We also need Mr. Kaiser, so if you can peruse the gallery and see if he's somewhere out there.
Found him.
All right. So we have counsel, we have our witnesses. I believe we have everyone. Okay. On the record. Good morning, everyone, and welcome back. This is the 3rd day of evidentiary hearings for Cranberry Point Energy Storage LLC, EFSB 21-02/DPU 2259. As on the other days, I will begin by explaining how to use Zoom today to ensure that everyone can fully participate in this hearing. For audio-only participation, attendees can dial in at 646-558-8656 and then enter the webinar ID, which is 875-6190-8820. My name is Andre Jubot, and I am the presiding officer in this proceeding conducting today's third day of evidentiary hearings. As part of the bench today, there are other members of the Siting Board staff: Andrew Green, Director of the Siting Board; Joan Foster Evans, General Counsel of the Siting Board; Wayne Mong, Assistant Director of the Siting Board; and Eric Logan Hughes, an analyst with the Siting Board. This hearing is being recorded by a stenographer, and video recordings will be posted at the Siting Board's YouTube channel for viewing. I will again explain the guidelines to use in speaking at this evidentiary hearing. There is a court reporter participating remotely who will transcribe everything said during this hearing. As we all rely on internet connection or telephones to participate, we could experience some technical problems such as sound from speakers, including potential background noise, video and audio issues, and potential delays. Please speak slowly and clearly to allow a speaker to be heard and to allow the recorder, the court reporter, to be able to record accurately. Allow a speaker to finish speaking before you begin, and pay attention to the video of the person speaking and my video. I will raise my hand as a sign on my video if I need to interrupt the person currently speaking and ask them to stop. May I have the appearances of counsel, please?
Sure. My name is Andrew Kaplan. With me is Paul Connolly on behalf of Cranberry Point Energy Storage, LLC. We're from the law firm Pierce Atwood, 100 Summer Street, Boston, Mass. 02110.
Good morning, Brian Bertram and Ryan Holmquist. We're attorneys for the intervener Save the Pine Barrens. We're of the law firm Miaris and Harrington, 40 Grove Street in Wellesley.
Good morning. I'm Catherine Cuthan. I'm here on behalf of Eversource Energy from the law firm of Keegan Worland.
Thank you. Today we have some business to attend to that was left over from Thursday. We have Mr. Kaiser, a witness for the company who testified last week and who was asked to return today pending resolution of an objection raised by Attorney Bertram, which I took under advisement. Mr. Bertram, have you reconsidered your objection?
I thought about it, Mr. Presiding Officer, and I think what Save the Pine Barrens would ask for is not an objection in the sense of striking the testimony, because it is obviously presents relevant information to the EFSB's decision. But we received an updated acoustic assessment a week before the hearing, which questioning established the data for which and all of the inputs was available last March. We had direct testimony presented on a witness that I got disclosed the night before, and we have some record requests that are going to bring in additional information on that after this live hearing closes. So what we would actually ask for is an opportunity to see what comes in and potentially submit, whether it's in the form of a record request or otherwise, rebuttal from an expert that we may retain. Because I think the state of the record at this point is far different from what's in the petition, what was publicly heard in July, or what was even disclosed before the hearing. And I don't think cross-examination is sufficient. And frankly, I don't want to strike.
Wait a second. We've got background noise.
Whoever is speaking and is not on mute, if you're not currently speaking to the rest of the panel that are on here, please mute your mic. I'm sorry, Mr. Bertram, you may continue.
No, I actually appreciate it. It's hard. It's easier to hear myself as well. No, we would simply suggest that we should have an opportunity to respond in substance. And I think that could be in the form of a record request to STPB a period of weeks after the pure tone analysis or the assessment of conditions comes in on the record request to the company, where we may present a response to that. And so, in terms of dealing with the objection, if you will, it's not to strike the evidence, but it's just to give us an opportunity to respond to all of this new information.
Okay, I'll hear from Mr. Kaplan.
First of all, it's hardly new information. The noise study was originally presented with the original petition. The noise study was updated as a result of questions by the Energy Facility Siting Board. The noise study was presented to MEPA in its SEIR on August 31st, 2022. Ms. Sheehan actually responded to that, so she certainly had knowledge of that, as so Save the Pine Barrens was or should have been aware of the noise study as of August 31st. Despite having the original noise study, Save the Pine Barrens at no point raised any issues about noise, didn't present any witnesses about noise. So this is actually the first time that we're hearing that they may have a noise witness. So I am, I'll certainly wait to see what happens with Mr. Bertram and what he decides to do. But I think it's misleading to say that all of this was just thrown at him at the last second. The witness of Mr. Kaiser came on because he actually wrote the noise study and was the author of the noise study. And in response to questions by Mr. Green, that is the reason that we asked Mr. Kaiser to appear on Thursday. He didn't add anything to the record. He merely clarified questions that Mr. Green had originally asked with respect to what L90 was and what the different columns were in the chart. The redirect that I presented was direct from questions that Mr. Green asked at the hearing on October 26th. So it's hardly new information, but willing to see where Mr. Bertram decides to take this.
Okay, so it appears to me that both parties will have the opportunity to address this in their briefs down the line. I think that the testimony of Mr. Kaiser is relevant, as both parties recognize, and it has been a present theme throughout not only the petition but also throughout the hearings. So I will overrule the objection as to the testimony of Mr. Kaiser and allow the testimony to stand. I would suggest that perhaps Save the Pine Barrens and Counsel for Save the Pine Barrens could make a record request and then respond in kind to the record request and include it in its brief. If that's a path that seems like it would be a little bit more manageable than doing anything special with the testimony that Mr. Kaiser's already provided.
I think that's manageable. And I think in fairness, I would suggest that we should probably respond to the record request in advance of our brief so that the company can see it before then. But, yeah, I want to see what comes in from the company's record request. But I think in general, that's a good approach. Yeah.
Okay. Okay, so we left off, Mr. Kaiser, we intended to have you come in today and provide any further testimony and sort of close out the questions that anybody may have for you. So with that, what I'll do is we left off at staff follow-up. So I'm going to ask the staff of the siting board if they have any further questions for you or requests, and then we'll move on from there. Okay?
Sounds good.
Okay. With that, if we have anybody from the siting board who would like to ask questions of Mr. Kaiser.
Thank you, Mr. Jabot. So I'm going to follow up from what Mr. Green had. I believe he'd started asking a record request to Mr. Kaiser. Is that correct? Do you recall that?
Yes.
Okay. So, 1 second. So I'm gonna read this record request and let me know if you need any clarification. So I'm gonna ask Cranberry Point or Mr. Kaiser, could you please develop and provide the details of a potential noise mitigation approach that would provide additional assurance that Cranberry Point Energy Storage complies with all aspects of the Mass DEP noise policy, and include in your response physical and operational changes due to the approach, any capital and operating costs associated with the approach, and anticipated noise measurements at model receptor locations with the mitigation approach. And all of this is hinging on whether Mr. Kaiser and Cranberry Point believe that additional noise mitigation is required.
That will be RR. That will be RR EFSB -13.
Does that record request make sense to you, Mr. Kaiser?
Yeah, with respect to, I think you started out mentioning that it was noise mitigation to ensure compliance with the Mass DEP requirements. Since the project appears to be meeting those standards, to what degree should I target exceeding those standards? Is there a preference in mind as a goal there?
I think we would. So, Mr. Kaiser, it sounds like, if I'm understanding right, if you're saying that you believe that the project as it is meets those standards, then the Mass DEP policy, I don't think we're trying to pinpoint any particular measurement or anything. But if it's your position and the company's position that no additional mitigation is required, then you should state that. This question is, I guess I should have started with the condition. So the condition is, if you believe something additional can be done, then please describe it as I had asked. But if not, please state your position on whether anything additional can or should be done.
Got it. Okay.
Okay. That's what I have for this morning. Does anyone else on the bench have a clarification or follow-up?
I'm sorry, do we have a record request number?
Yes, it's RR EFSB -13.
Thank you.
Are there any further questions from either Save the Pine Barrens or the we'll start with Save the Pine Barrens for Mr. Kaiser?
I don't have any questions, but consistent with the discussion we just had before, I guess I would ask the EFSB to make a record request of my own client in the form of any rebuttal response to either the conditions or the pure tone study or the most recent acoustic assessment that has been received into the hearing evidence.
Okay.
Wayne, would you?
I would, Mr. Jabot, should we ask this when it's time to ask questions of the interveners, or I don't want to do it out of turn?
It would, I mean, at this point, it's dealing with Mr. Kaiser. We might as well do that just in case Mr. Kaiser is not able to stick around later on.
Okay, so I guess I'll rephrase Mr. Bertram's record request. So this record request is directed at Save the Pine Barrens, and it's asking, so the siting board would like to know whether the Save with the Pine Barrens witnesses have any rebuttals as to the testimony provided by Mr. Kaiser today and in future record requests and in the past week of hearings. And I would like to also add, if there's additional experts that the intervener is going to employ, they should notify us and state that in the record request response.
Right.
I anticipate, in fact, that we would do it before we responded to the record request to make sure everybody knows what's going on and in fairness to the company.
Thank you.
Okay. That would be our EFSB -14.
Thanks, Mr. Jabal. I had so forgive me if this has been answered, but I think staff follow-up would have also included other Cranberry Point witnesses. Mr. Kaplan, would these witnesses be available in the afternoon, or how were you envisioning some cleanup by staff?
No, I believe we, on Thursday, the only thing that was pending was Mr. Kaiser. I think we finished up with all the rest of the witnesses for the company.
Okay. Mr. Jabot, so this is my mistake, but could I issue a record request such that the company could answer just a short question on tree mitigation, if that's okay?
That's fine. Does the company have any objection to the question being asked now that the panel has withdrawn?
No, we have no objection, and I think it's a very good idea to do it as a record request.
That's fine. All right, Mr. Wong.
Thank you. I'm really quickly just pulling up the information request that I'm going to refer to. If you could indulge me for a couple moments. But so thank you for waiting. This record request question is going to be referring to the company's response to EFSB-LU-6. So in that question, the deciding board staff had asked how the company had arrived at a tree replacement value of 10%. And the response didn't, might have missed that answer. So I'd like to reissue that question, which is, could the company explain its methodology or its reasons for the tree replacement value of 10%? Whether it's as advised by the town or if it's a standard or best management practice. Does that question make sense, Mr. Kaplan?
It does. Thank you.
Yep. That's all I have.
Okay. Does anyone else have have any questions, particularly with regard to Mr. Kaiser or any other cleanup matters from the siting board?
Do we have a record request number?
Oh, sorry. The record request is RR EFSB -15. Okay. Mr. Kaiser, thank you very much for coming back. I would, I believe, unless there is redirect from the company for Mr. Kaiser, we would be finished with Mr. Kaiser. So with that, Mr. Kaplan, do you have any further questions for Mr. Kaiser?
We do not. Thank you.
All right. Thank you, Mr. Kaiser, for your time. And thank you for coming back today. I think that concludes your testimony for today.
Very good. Thank you all.
Are there any further matters that the parties would like to raise today before we begin with the direct of the intervener witnesses?
The company has none.
Intervener has none.
Are the interveners witnesses that will testify today present?
They are, Mr. Presiding Officer.
Mr. Bertram, would you please identify your witnesses?
Save the Pine Barrens is offering 2 witnesses for cross-examen today, Mr. Milosh Pachowski and Mr. John Hinckley.
Mr. Petrovsky and Mr. Hinckley, if you could please raise your right hand and make sure that I can see them on camera. Okay. Do you solemnly affirm and swear that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Please let the record note that the witnesses have been sworn. Mr. Bertram, if you may proceed with the direct of your witnesses.
Thank you, Mr. Presiding Officer. I don't believe we have anything for direct, but I will give either witness, if they want to make any correction at this time, please go ahead and speak. All right. Here
I have 2 minor corrections that I'd like to make.
All right. Mr. Hinckley, what are those corrections?
Sure. So the first one is on page 10, line 22 of my pre-filed. I would like to remove the comma that's between carbon and monoxide. Good there. Okay. The second one is on page 11, line 18. There is an extra period at the end of the sentence, so would like that period removed. And that's it.
And are those your only corrections, Mr. Hinckley?
Yes.
Okay. And with those corrections in your testimony, is otherwise true and accurate to the best of your knowledge and belief?
Yes.
Okay. And do you adopt it?
Yes.
And Mr. Pachowski, I understand you have no corrections?
That is correct.
Okay. And do you adopt that as your testimony?
I do.
All right. Mr. Presiding Officer, my witnesses are available for cross.
Okay, Mr. Kaplan, are you ready to proceed with cross?
I am.
Yeah, you may begin.
Does the staff have any questions, do you know, at this point?
I do not believe so. None of the staff has informed me that they wish to cross at this point, to question at this point.
Mr. Jabal, if I may, we have a few questions, really minor questions, but I believe Mr. Hughes had prepared maybe just one all-encompassing question. Mr. Kaplan, did you intend first for us to go first? Is that why you asked?
I mean, in the ground rules, that's what happened, but I'm happy to go first if Mr. Jabot would prefer that.
If we have one question, let's ask our one question and then clear the floor for you, Mr. Kaplan.
Okay, thank you.
Right.
Yeah, sorry about that. So yeah, my one question is fairly straightforward for say the Pine Barrens. Was just wondering if they had a chance to review the second round discovery response that the EFSB received from the company on October 20th, 2022. That's the question. For say the Pine Barrens.
To be clear to my witnesses, the question is directed to Mr. Hinckley and Mr. Pachowski.
Apologies.
Sorry. Okay. I guess I'll go first. Thank you. I was waiting for some instruction there. I have not had an opportunity to sufficiently review the information. It was passed along to me on late Wednesday, the 26th of October. And I have not had the time due to other commitments, currently traveling and have been traveling, to form an opinion on that new information.
If what you are referring to is a document that was filed on October 20th, I have reviewed that. That would be, yep. So this is EFSB 21-02, looks like. Exhibit EFSB-S-37.
Yes, the EFSB-S-37 is one of the responses to a list of discovery questions issued on or responded to on that date. So I just wanted to get the opportunity to comment or ask further questions on any of those responses that were filed if you have them. For Mr. Nicholas.
I believe that would be you, Mr. Hinckley, since you have reviewed it.
Thank you. Apologize, I didn't catch on to what was being asked. So am I being asked to ask it to propose if I have any questions in response to the information response, or are you asking me to comment on what I on my observations from reviewing it? Happy to, whatever you'd like.
Yeah, it's essentially an opportunity for you to ask questions if you have any on the responses that were filed. And if you have none, to make any comments if you have any to make.
I don't have any questions. Let's see here. I do have a few comments. Bear with me for a moment. Reference number 1. First sentence after it's the second part of the sentence, which it's referring to the UL 9540A test report and the Fisher engineering report, which shows that in the credible worst case scenario, fire propagation of thermal runaway does not occur, nor does air pollution. I agree that fire propagation did not occur based on what was provided in that document. As far as I can tell, don't agree at this time that that document indicates that there was no air pollution. The document does mention hydrogen fluoride HF emissions were produced and were monitored at a constant level of around 0.1 to 0.2 parts per billion over about a 2.5 hour period. So I wanted to mention that. That's my first comment. My second.
Could you clarify which exhibit you're referring to exactly?
Sure. STPB 1-1.
Okay, to be clear about the question that I was asking, the documents, if you had any comments or response to, were the discovery requests that the company responded to on October 20th. So those are all categorized by EFSB at the beginning, which is the siting board's discovery, not intervener discovery.
Okay. Very good. Well, you know, what I'm responding to is EFSB 21-02, which in item number 1 cites STPB 1-1. So am I on the same page with you with regarding that? Am I correct so far?
Give me one moment to pull up the document, because I think the document that you're referring to does say EFSB 21-02 at the top, which is just the docket number for the proceeding.
Okay.
But I'm referring to discovery responses that are tagged with that were issued by the Energy Facility Siting Board, not Save the Pine Barrens. So the STPB discovery, I believe, were issued by Save the Pine Barrens to the company, not issued from the Siting Board to the company.
Okay.
Mr. Hughes, if I could add a little bit of clarification, I think the witnesses, so basically what we're asking is, right before the hearings, we'd asked a series of questions to the company about safety and other issues. And I understand that Mr. Puchovsky and Mr. Hinckley, you are expert witnesses from the Save the Pine Barrens end of that. So we were asking for your expert opinion on whether the company's responses to the siting board, you know, whether you agree or you disagree, or if you have comments on it, basically, just to get, you know, more color on what we got, if that makes sense.
Yes, it does. Thank you. So I just want to clarify if I'm in the, it appears that maybe I'm in the incorrect, referring to not the correct document. Is that possible, Mr. Hughes, or?
Yeah, that's my understanding, is that you were referring to the discovery responses that were given to Save the Pine Barrens for the Save the Pine Barrens line of questioning.
Okay.
And we're referring to the Energy Facility Siting Board's line of questioning, the responses that we received. And if you have any questions or comments on
excuse me,
our questions.
Just as a point of clarification, I think Mr. Hinckley earlier was referring to the latest round of discovery that came in, and I think he had cited to EFSB S37, which is the, and you were looking at item 1. Is that the document that you were looking at?
Yes, that is. I apologize if I muddied the waters here, folks.
No, I think that's actually my fault. Yeah, you're correct, counsel. So yeah, sorry, please continue with your comments and your responses.
Okay. Thank you. So I addressed line 1 or reference number 1. The second comment I had is regarding reference number 11, and just wanted to make a clarification. I'll read the first sentence and then I'll make the clarification. It says the connection attempted by Hinckley of comparing BESS and fossil power plants, manufacturing plants, and colleges/universities is not relevant to this case because emissions from BESS thermal runaway events are significantly lower compared to emissions released during normal operations of other types of facilities listed by Hinckley. For example, the facility types listed by Hinckley, i.e. stationary sources, reported over 45.
I'm sorry, sir. Can you slow down? I can't understand.
Oh, I'm so sorry. I
For
apologize.
example, the facility types.
Yes, for example, the facility types listed by Hinckley, i.e. stationary sources, reported over 45,000 tons of carbon monoxide emissions in Plymouth County, according to US EPA 2017 National Emissions Inventory. I agree that this proposed project would not, under emergency thermal runaway conditions, emit at that level of air pollution. It's just my point that there will be potentially similar air pollutants that would be emitted during a thermal runaway. So just wanted to make that clarification.
Excellent. Are there any other questions that you wanted to respond to or that you had comments on?
I do not.
Excellent. Thank you for that. And again, apologies. That was absolutely my mistake earlier. I misheard you when you were reading the reference number 1. I thought you were referring to the document. So that's 100% my fault.
No problem.
And then Mr. Gibault, do we want to allow Mr. Pshovsky the opportunity to respond to the EFSB second round, the company's response to the EFSB second round of discovery through a record request? Or no?
That you can ask him if he has any response to it. If he's reviewed it and has a response, he may do so.
So, Mr. Pshovsky, is it correct that you have not had the opportunity to review it?
Correct.
So that says that wraps that up. So I think that's it for my questions.
Okay, do any other staff members have any questions for either witness? Seeing none, I believe now the floor is yours, Mr. Kaplan.
Thank you. I just want to clarify that you did not ask Mr. Pshovsky for a record request asking for him to comment on S-38, correct? He said that he has not read the information and could not comment. Just want to make sure I followed that correctly. Okay, thank you. So good morning, Mr. Hinckley. My name is Andrew Kaplan. This is Paul Connolly. We are representing Cranberry Point Energy Storage, LLC. And we've got a few questions for you this morning. First, I just wanted to make sure you were talking about EFSB S-37 and reference number 1. And you indicated that in that response, you agreed that there was no fire propagation occurred under a worst case credible scenario based on what the Fisher report and UL 9540A demonstrated. Is that correct?
Thank you for restating that. Allow me to update my response to that. I think there's a little more unpacking that we need to do of that event, and that it references a credible worst case scenario, and it's outside of what I was asked to do to evaluate if that was or was not a credible worst case scenario, meaning I wasn't asked to assign credibility to it. What I was asked to do is to look at potential emissions arising from an event that would be larger in scale. In other words, more cells igniting and producing emissions. So just wanted to clarify that. In reading through the...
Thank you. So if you actually turn to, let me just, I just want to clarify what you're just saying now. So if you turn to page 17, line 6 of your testimony, you indicate that significant thermal runaway event, and you mentioned the word significant thermal runaway. Can you define significant for me?
That's a great question. I appreciate that. I would not define it as what was described in the Fisher report. I would start by defining it as event, which was larger, had a greater spatial extent of batteries that were ignited. And I would then go beyond that and define it as one that is similar in temporally and spatially as the events which are put into table 1, my table 1 exhibit. There's 4 instances that I noted, 4 events where there were thermal runaways, and those events lasted from anywhere from less than a day to potentially up to 13 days, and involved a thermal runaway that encompassed most of at least one, what I would call a megapack. It isn't necessarily a Tesla megapack, but at least one structure comparable in size to one of, generally speaking, roughly similar to one of the megapacks that's being proposed. So
let's break this down a little bit so make sure I'm understanding. So a significant event is a credible worst case scenario. Is it worse than a credible worst case scenario? Is it less than a credible worst case scenario? I don't understand what significant means.
Understood. Significant would be bigger or worse than the credible worst case scenario that was described in the Fisher report.
Okay, and can you tell me where in any of the documents that you reviewed from 2014 on, where you found any indication that there was a thermal event that occurred that was more than a credible worst case scenario as defined by 9548?
The documents that I reviewed and submitted were, the intent of submitting those was to show that there are air pollutants that can potentially be released during a thermal runaway event. Those documents don't help a person quantify the extent of a thermal runaway event, and can't be used to quantify a thermal runaway event necessarily. Does that answer your question, sir?
Not really, but I'll move on. Under normal operating conditions, does a battery energy storage system emit fossil fuels or anything, actually?
I'm sorry, emit fossil fuels, what?
Or anything? Is there any emissions?
I'm not aware of a BESS producing emissions during normal operating conditions.
Does a fossil fuel peaking plant have emissions in its ordinary course of operations?
Yes,
Your
it does. Sorry for interrupting. Yes, it does.
Thank you. So if a 150 megawatt fossil fuel plant was built in this location and interconnected to the existing 345 kV line that's already there, what emissions would be produced on a daily basis? Are you aware of that?
While discharging electricity into the grid and while well, let me back up here. While it operates, a BESS would not.
During a normal operation of a fossil fuel peaking plant, what's being emitted?
So by the peaking plant?
Yep.
What kind of peaking plant are we talking about? What's it fired with?
Gas.
Just natural gas peaking plant.
Yep.
So the peaking plant burning natural gas would emit what's called criteria pollutants and hazardous air pollutants. Generally, those are the two categories of pollutants that would be emitted.
So would you agree that that is more than what a BESS would produce in its daily operations?
Yes.
I have no further questions. Thank you very much.
Could I just do a quick follow-up on, this is Paul Connolly, Mr. Hinckley, I'm sorry, we haven't been.
Nice to meet you.
Nice to see you. Just wanted to ask you one follow-up question with regard to the Fisher report. You indicated the Fisher report on the 9548 test showed that there was a release of HF gas, is that correct?
Yes.
What was the amount of the release?
Well, the mass of the release was not provided. The concentration that was measured was provided. It's my understanding that HF was measured in 2 locations and that the concentration ranged from 0.1 to 0.2 parts per million.
Was that significantly below the health indices that would say that it was a danger to people?
I'm sorry, the health indices, what?
That would say that it was a danger to people?
So there's more to unpack from that in that I'll first of all mention that the standard that it was compared against was higher than the concentrations that were monitored. Those concentrations I independently compared with the Massachusetts DEP air toxics guidelines. And the air toxics, they're presented in 24-hour and annual format, meaning there's a 24-hour concentration and an annual concentration guideline level that is presented. So let's just take the lower of the 2 HF values that were monitored, 0.1 parts per million. That corresponds to 100 parts per billion. And the 24-hour guideline in Massachusetts is 0.83 parts per million. So let me back this up for a second. Let me make sure I read this correctly. So the 24-hour guideline is 0.83 parts per billion. And if we take the 0.1 parts per million that was monitored, that converts to 100 parts per billion. So 100 parts per billion exceeds the guideline of 0.83 parts per billion. So I looked at a different standard. If this was a peaker plant and it emitted hydrogen fluoride, then it would likely be subject to the hydrogen fluoride guideline. So
just so I understand it, you're saying the hydrogen fluoride guideline is 0.83 parts per billion?
That's correct.
So that's less than 1 per billion.
Correct.
Okay, we'll come back to that later. Mr. Pachowski, I just had a few questions for you, if I could. First of all, let me go through your curriculum vitae as listed in your testimony. You are a member of the National Fire Protection Association, is that correct?
I am a member, correct.
Okay, and what is that organization?
The NFPA is a private nonprofit organization headquartered in Quincy, Mass. One of their functions is to promulgate codes and standards associated with fire and electrical safety. And those standards are developed on a voluntary basis. And then various jurisdictions, organizations, companies would adopt those standards as their guidelines, rules, or laws.
And what are the standards to purport to do?
Which ones?
Let's take have they developed standards for BESS?
I'm sorry, I couldn't hear you, Mr. Connolly.
Have they developed standards for a BESS battery storage facility?
NFPA has developed NFPA 855, which deals with energy storage systems. Correct.
Okay. Looking at, have you read the Fisher report?
Yes, the one that was submitted, I don't have the exact docket number, but the one that was submitted as part of the information I reviewed when I prepared my initial testimony.
Yep. Okay. And was the or is the Megapack 2 that the company is proposing to build, does that meet the NFPA standard fire code? The one that's listed in the Fisher report is the 2021 standard.
The Fisher report?
Lists the number of standards that.
I'm sorry, could you begin the question again?
I'm reading from page 1 of the Fisher report. Do you have a copy of it there?
I do not, but if you give me a reference, I can get it. What does it say?
Okay. The Fisher report is the report showing the test results for the Tesla Megapack 2 under 9540A.
Correct. So the Fisher report responds to a test report that was completed on a Megapack. And that Fisher report, essentially, a Megapack 2, a certain arrangement of a Megapack 2. And that Fisher report indicates it reviewed the test report that was submitted.
The Fisher report also lists a number of other standards that the Megapack 2 has met. And the first question I had for you, has it met the NFPA standard fire code for battery energy storage facilities?
It meets a portion of NFPA 855, correct.
Does it meet the 1923, I'm sorry, the 2023 edition?
It meets a portion of NFPA 855. So
And which portion does it not?
Well, NFPA 855 encompasses the safety of energy storage systems. And one of the first aspects of that is to do a hazard mitigation assessment. And then there's multiple steps that are done. One of the requirements is to conduct a test per UL 9540A, of which there are a series of tests in UL 9540A. Of those tests, there is a cell level test, a module level, a unit level, and an installation level. Test report I saw had to do with a unit level. To get to a unit level test, there needs to be a cell level test and a module level test, which were not included in the information that I had reviewed when I completed my analysis and did my initial opinions. Of that
And I
unit,
take it.
I'm sorry, would you like me to continue?
No,
or?
go ahead. I'm sorry. I didn't.
Yeah, I'm
mean to
sorry.
interrupt. I thought you had finished.
No, and of that unit level test, it refers to a module level test, both under UL and in that test report. There's key information in that module level test that needs to be included in the unit level test. That documentation I did not see. So it's difficult for me to say, again, your question is very over encompassing. It satisfies a portion of NFPA 855 because Fisher Engineering reviewed a test report, which is required by NFPA 855. So that part is satisfied.
I take it from your answer to an earlier question by staff, you have not reviewed any of the data that was submitted in response to the staff request to Cranberry Point, including an HMA and including the emergency response plan updated.
I was not able to view that information in sufficient detail to cast an opinion. However, in perusing it, I did see that much of it was still in draft form.
Wouldn't you say that it would be draft form until the project design is completed and everything is finished?
I don't know what you mean by draft. I just saw the word draft, which to me means incomplete.
It means that things can change, does it also? Doesn't it also?
I don't know how you go about with construction of any project until you finalize a hazard mitigation assessment and everything associated with it.
You understand that the Carver Fire Department will receive an amount of money in order for them to hire an expert to comment on the HMA and decide whether or not it should be changed?
I'm unaware of that.
Okay. So if it can be changed by the expert hired or suggested changes by an expert hired by the town of Carver's Fire Department, then it would still be draft until it was in final form after review by the fire department and by the expert hired by the fire department. Is that correct?
It would be draft until the person producing it finalizes it.
And the person producing it wouldn't finalize it until all comments are in, including, by the way, Mr. Wachowski and his comments on it.
I don't know to what effect I influence the hazard mitigation assessment, I was asked to comment on it. But until all information is available as required by the HMA and as required by NFPA 855.
When the HMA is finalized, then we have in the ERP. Have you looked at the draft ERP that was filed as well?
I looked at a draft ERP prior to the submission of my testimony.
Did you look at one subsequent to it?
I have not. And again, just for the record, I received this information late Wednesday, the 26th of October. And I have been traveling and continue to travel. So I just have not had an opportunity to review that information in sufficient detail.
Looking at page 9 of your testimony, you indicate that a container can be equipped with a BMS heating, ventilation.
I'm sorry, Mr. Conley. Mr. Conley, I can't hear you. You indicate that a container can be equipped
with a BMS. Can you tell me what a BMS is?
I believe it's a battery management system.
Okay. Do you know whether or not the Tesla Megapack 2 has such a system?
I believe it does.
Okay. You also indicate that it could have venting. Do you know whether or not the Tesla Megapack 2 has venting?
There's some discussion of that.
You know if the Tesla Megapack 2 has an igniter system to take care of any gases that may arise from a thermal runaway?
Again, I have read in the documentation that does occur. However, what is missing is any documentation in terms of the performance of such a system and validation of its effectiveness.
Looking at on page 6 of your testimony, you indicate that the higher density in the batteries creates more danger. Is that correct?
Yes, in general.
Okay. Do you know whether or not the batteries being used in the Tesla Megapack are lower density?
As compared to?
Higher density. I refer you to an exhibit that was requested by the Siting Council, the DOE report, certain chapters, and I'm reading from chapter 3.
Objection. Can we get an exhibit number, please?
Yep, I'm sorry. EFSB G25. It's a document with 3 chapters of a report from DOE. Other chapters are not yet available.
I don't have that information here in front of me. And could you summarize what specifically you're asking?
That the LFP used by the Tesla Megapack.
I'm sorry, LFP, could you describe the acronym?
Olivine structure, LIFEPO4, has a lower average potential versus an Li/Li2 than all other popular commercial positive electrodes. And it corresponds.
I'm sorry, Mr. Conley, I just can't hear you clearly.
Okay. It has a lower density. Have you seen that report?
I don't recall. In general, my statement is that as battery technology develops, the energy density, the amount of energy that can be stored in a smaller volume of space increases. And in general, because you have higher energy densities in a smaller volume, you are able to pack more of these battery systems together. So a general statement would be that that creates a greater hazard. Now, how different manufacturers deal with the internal components of transferring that energy, whether it's charging or discharging, is also something that needs to be evaluated and something that I would expect to see in a hazard mitigation assessment.
And you haven't read the latest draft HMA?
I have not read a draft. No, I have not had an opportunity to read the latest, actually, not the latest, the first, because an HMA was not provided to me when I began reviewing this for my initial testimony.
We have nothing further. Mr. Barczewski, at this point in time, I wonder if we could take a 5-minute recess.
That's fine. Let's my computer says it's 11:10 right now. Why don't we make it a 10-minute recess and come back at 11:20?
Thank you, Mr.
Thank you.
Presiding Officer.
we'll give it another minute and just wait for everybody to come back. Okay, we're just awaiting the return of the company's counsel. There they are. Right, it appears everyone is back. Mr. Kaplan, you're still on mute.
Mr.
Nope.
I think it'll take a while for them to get back on.
Okay. Nothing yet, Mr. Kaplan. Since you're still showing is muted on the Zoom screen. Here we go.
Doesn't matter.
Okay, I think you're back.
Excellent.
Okay.
Thank you.
Mr. Hinckley, I just have one, actually a record request. Can you look at?
We're not on the record.
You're muted, Mr. Dubell.
Oh, I think you're muted now.
Yes. Everybody is back. We're now on the record.
Mr. Gabo, I just have a couple of questions of Mr. Hinckley.
That's fine. You may proceed.
Thank you. Mr. Hinckley, do you have the Fisher Engineering report with you?
Yes, I do.
Can you look at page 21 of that report?
I'm there.
Okay. If you look at the long paragraph, the last 5 lines.
Yes.
HF was detected at values of 0.10 and 0.12 parts per million. Do you see that?
Yes.
Okay. And in the two sampling locations, the trace quantity was detected over the entire 2.5-hour test duration. Do you see that?
Yes.
The HF, according to NIOSH, HF's immediate dangers to life or health, its value is 30 parts per million. Do you see that?
Yes.
Okay. Indicating the quantity of HF detected during the UL 9548 test level test is well below 2 orders of magnitude lower than the IDLH value for HF. Do you see that?
Yes.
Okay. Could you, as a record request, show me the calculation that you get to 100 parts per billion based on what the Fisher report is reporting of 0.10 and 0.12 parts per million?
Sure. Are you asking me to submit something now, or
Calculate, no,
just to walk you through the
as part of a
calculation?
record request. As part of a record request, you can submit it in 5 days from now.
Be happy to.
That will be RRCP-1.
That's all.
Thank you both, Mr. Hinckley and Mr. Pachowski. The company has no further questions at this time. We reserve the right to ask questions after redirect.
That's fine. Prior to redirect, well, since you've had direct and cross, I'll ask the staff briefly if they have any further questions prior to redirect. I do have a couple of questions. We'll start with Mr. Pachowski. Mr. Pachowski, did you have the opportunity to watch or read the testimony of the company's experts that testified last week concerning, in particular, safety?
I have not, no. I have not watched it, nor have I had the opportunity to.
Okay. That's all for you, Mr. Pachowski. Mr. Hinckley, with regard to the concentration of HF, can you tell us where the measurements of HF were taken? If you can, were they close to the unit that was being tested? Further away from the unit that was being tested?
The report states that they were taken approximately 20 feet upwind and 5 feet downwind from what's called the initiating MP2, where the thermal runaway was initiated.
And were these the only, was this the only, I mean, based on these measurements, could you tell whether or not there was dissipation of HF the further away you got from the unit?
No, because there was essentially one downwind location. So in order for me to draw a conclusion around dissipation, I would need to see subsequent locations where monitoring occurred downwind. I mean, at least one other location where monitoring occurred.
Based on your experience, can you opine as to whether there would be more or less concentration as distances from the event grew?
I would expect there to be dissipation continually occurring, to increase steadily from the point of release further away from it. So the plume of emissions would disperse over time and over distance. Well, not just, I mean, let's just stick with distance for now to keep it focused, but.
Forgive me, I'm not a scientist, and you would know better than I would. Is there a calculation that can be made as to the rate of dispersion, or the rate of let's say reduction in parts per million or per billion over distance?
There are a number of equations that can be used to calculate dissipation over distance. I don't have a specific equation name or number that I can provide at this time, but yeah.
And when you received the results, did you perform any of these calculations to see if the particles, the HF particles, would dissipate by the time, let's say, that they reach the closest to butter?
I did not perform those calculations. I would not have had the time to perform them, and nor do I think I would have had all the information I would need to perform them, in that I haven't been privy to all of the design information for the project, and so I would need to look at that first, and there'd be a lot of this is something that we'd have to put some time into conceptualizing what the release would look like, and how where the release would occur from what the dispersion characteristics were. So if you're calculating what I call dispersion, you have to take into account wind speed, wind direction, the temperature of the release, the mass, the pound per hour, gram per second, whatever mass emission rate of it being released, the orientation of the release, whether it be horizontal or vertical. So it's not a quick back of the envelope kind of calculation that would have to be done, but certainly some simplifying assumptions could be made to at least understand proportionally how much the HF concentration would decline with distance away from the source. So, for example, over 300 feet, we saw a 50% reduction. Over 900 feet, we saw a 75% reduction, of that nature. So making some simplifying assumptions, we can do some calculations to better our understanding of how that dispersion would occur. I just want to stress that it's not a back of the envelope matter, because you have a lot of factors at play, meaning changes in wind speed and direction, changes with the source of emissions, and so on. So, but I do think it's possible to develop understanding of the dispersion as it occurs downwind. So, sorry, I felt like I took a little more time than I needed to on that response, but
it's appreciated, because all the testimony that's given, it's educating us as non-experts as to the nature of the project and some of the things that we look at. Another question for you: did you have the opportunity to watch or review the testimony of the company's witnesses that were on last week concerning safety?
I did not.
Okay.
I was traveling all last week, so.
Okay, just wanted to know if you'd had the opportunity to review that testimony. I have no further questions for Mr. Hinckley or Mr. Pachowski. Once again, if none of the other staff members have any, then we are ready for redirect. So do any staff members have any further questions? Seeing no, Mr. Bertram, are you ready for redirect?
I am. I think I have just a handful of questions.
Sure.
So I'm going to start with Mr. Hinckley. Mr. Hinckley, you testified a bit ago in response to the company's questioning about health standards. I think that's the phrase that's being used. When you reviewed the Fisher report, what health standards were cited in that report?
I believe one health standard, the IDLH, which is immediately dangerous to life or health. So it's my understanding that that is the health standard that was applied to that test that was performed.
Okay. And when you testified in response to that, what health standards were you testifying to?
I was testifying to the air toxics standards that were promulgated by the Massachusetts Department of Environmental Protection, Mass DEP, that are implemented for projects that are going to need an air emissions permit.
So when we talk generally about health standards, I just want to make sure the record is clear. There's a different set of health standards that you're speaking of than are cited in the Fisher engineering report.
That's correct. So I was just curious because the project is going to, appears to be, is being proposed for Massachusetts, what other standards might apply. And because I do air emissions permitting work in Massachusetts, I was curious what the Mass DEP air toxics guidelines were, specifically with regard to HF. So that's why I felt it was important just to note that.
Okay. I'd like to turn to Mr. Puchovsky. Mr. Puchovsky, you were asked about a couple of documents that have been received into the record in this proceeding on October 20th, the HMA and a subsequent draft of the ERP. Do you remember being asked questions about both of those documents?
Being asked questions today?
Yes.
Yes.
Okay. Can you just clarify for us? I think there was a lot of terms used between review, analyze. Can you clarify for us, whether you've reviewed those documents and if you have, to what extent?
Sure. So I did receive those documents last Wednesday. I believe it was October the 26th, later in the day. I did view those documents, scanning them, so I'm aware of them. I did note the length of those documents, quite voluminous, and that the word draft appeared on some of those. So I was able to scan those documents to get a general sense of what they might be about. But I have not had the time to sufficiently analyze what is in those documents and render an opinion, because part of that analysis would be not just those documents independently, but how they interconnect with other documents that have already been submitted.
Okay. If provided additional time, would you be able to do so?
Yes.
Okay. At this point, I'd actually like to make a record request for this witness to take a look at two exhibits. The first being S-37, which I believe contains the draft HMA, and S-44, which I believe is the revised ERP, so that we can get into the record the benefit of his opinions, if any, once he's had an opportunity with those documents to do the work he requires to do.
Just for my notes, if you could just simplify, the request is for Mr. Puchovsky to
review and submit an opinion with respect to S-37 and S-44.
S-37 and S-44. Okay, that will be. Does the company have any response prior to me assigning the record request number?
So I would point out that this information was submitted to Save the Pine Barrens on October 20th. Save the Pine Barrens has two expert witnesses who understood, I believe, that they were to come to the hearing today prepared for cross-examination, and clearly they are not. As we would be able to cross-examine the witnesses, we would be able to glean what they had to think about what we prepared and what has been submitted into this docket. We're now unable to do that. So basically, what Save the Pine Barrens is asking is just write down what you think about, without an opportunity for cross-examination, just write down what you think of what the company has responded to. And it doesn't give the company an opportunity. I mean, the whole purpose of this proceeding was to go back and forth so we could figure out and help the Energy Facility Siting Board make a decision. And I'm quite, I mean, honestly, in all the years I've done this, I've never been to a hearing where the two expert witnesses haven't been prepared to be an expert witness. Expert, not just a witness, an expert witness. It's shocking to me. And it is problematic to the company. It puts the company in a bad position because we don't have an opportunity to cross-examine the witness. So I am happy to speak with Mr. Bertram and see if we can come up with a solution to this. But I object to the fact that you're going to just ask a record request asking Mr. Pachowski to, make comments back on questions that we were asking.
So given that, I'll take that under advisement, the objection. What do you think, Mr. Kaplan, Mr. Bertram, that you can discuss this over the lunch hour and possibly when we reconvene after lunch, give me a response as to what your negotiations turn out?
We can certainly discuss it. I'd like to point out that, we had a tremendous volume of additional information come in at the 11th hour in this proceeding. The original petition and analysis haven't been updated at all. I think the ERP doubled in length a week before the hearing, and we worked very diligently and hard as interveners to line up witnesses on what was an expedited hearing schedule. It's difficult for interveners to participate in these proceedings, and we got our witnesses here. We're trying the best we can under their scheduling limitations to have them prepared. They worked hard on pre-filed testimony. I think that a lot of these documents could have been updated sooner in response to information requests, and they came in afterwards. So I do bristle a little bit at the suggestion that my expert witnesses have not worked hard to prepare themselves in this proceeding.
Well, I would point out that of the 12 questions that the Energy Facility Siting Board asked Mr. Hinckley, 2 of them involved whether or not there were typos. The first did involve a typo, the second did not involve a typo. The other 10 responses were, I'm not an engineer, I'm not a toxicologist, I haven't looked at whether or not the documents from 2014 are relevant or not. So I appreciate that the witnesses worked as hard as they could, but they certainly didn't add anything into this proceeding. And I didn't hear from Mr. Bertram whether or not he would appreciate, or would not appreciate, but would work over the lunch hour to try to figure out a resolution to the problem that he finds himself in.
That is actually the question that I'm looking for the answer to right now. And I understand that both of you have other arguments to make, but I would just like to hear that if you are willing to work through the lunch hour and then get back to us, I will take the objection under advisement until that point in time.
I think we can certainly do that. Attorney Kaplan and I have worked constructively on issues other than these in this proceeding, and I have no doubt we can discuss.
That sounds good.
I believe that as well.
Thank you. I'm sorry.
Paul Connolly, could I just have one more question based on staff's questions, your questions, and redirect?
Sure.
Mr. Hinckley, what is the Mass DEP threshold level? You said it's 8.83 parts per billion. Is that correct?
Yes,
Over how long a period of time is that measured?
24 hours.
What was the measurement of in the Fisher report?
2.5 hours.
Significantly less.
Well, it was less. I agree with you on that, but the level was continuous. The report notes that, say, 0.1 pounds parts per million, that level, it appears the report says that that level was sustained throughout the 2.5 hour period. So assuming that it continued over 24 hours or more, then we would be exceeding the guideline, the 24-hour guideline at that location, theoretically. We're about 120 times over it. And so we don't know what it would be downwind. So.
And if it didn't continue for the 24-hour period, it would be less. Is that correct?
The concentration would be less. You would be averaging what happened over the 2.5 hours into the 24-hour period. I will just reiterate that what was measured was apparently looks to be 120 times over that standard. So we would have to take that into account as well, assuming that the guideline applies in this case.
You're going to provide me a calculation of how you get there.
So I can, yes, I can do that. But just so I'm clear on what you're asking for, you had indicated you'd be interested in the math we did to arrive at showing that we would be over the 24-hour guideline. Am I being asked to project what the concentration would be at distances downwind or not?
No, just your calculation and all assumptions that go into your calculation.
Okay, like I said, I'd be happy to do that.
Is that a record request?
That is, I've already asked the record request.
Okay, that's just making sure. And that would be CP2. RRCP2.
Yep.
Yep.
Pretty much the same.
Okay. All right. Mr. Bertram, any follow-up?
Yeah, I just had one and then we got into this. I just wanted to ask Mr. Pachowski, do you have a complete set of the exhibits available to you at present?
I believe so. There was one that was sent to me over the weekend. Yes.
Yes. Okay. That's it. Thank you.
Yep. We have one more matter from staff, I believe, to address regarding a record request.
So I'm gonna start, and then please, Ms. Foster Evans and Mr. Jabot, please help me if I'm misstating, but I'd like to withdraw my earlier record request 14. And that record request was to save the Pine Barrens on some sort of rebuttal towards record requests that are coming in. I'm going to briefly explain the reason is that we don't want to add extra process to this. And if Save the Pine Barrens has any requests when answers come in, they can feel free to do so at the time. Ms. Evans?
Yes, I think just to add to what Mr. Wang said, I think that there was a record request that we had posed to the company regarding some noise analysis. And if correct me if I'm wrong, Mr. Bertram, that you had said that you might want to look at that and get more information. I think that the appropriate process would be, once the record requests come in, and if saying the Pine Barrens thinks that it needs more process at that time, once you see what comes in, then you make a request for it. So I think we jumped the gun a little bit by asking the record request number 14, and it'd be best that once the record requests come in, if Save the Pine Barrens feels as if it needs additional record request or additional process, it asks at that time. And obviously the company would have an opportunity to weigh in that at the time also.
I understand. So you're essentially referring to a motion practice after the fact to either reopen the hearing and accept something additional into the record or something similar.
That's correct. But I think it's best for you folks to determine what you need as opposed to us asking the record request for you. So if you need more additional process, you would let us know.
That's fine. And I think this all started with my suggestion. So I guess I want my record to be clear then that this is all in response to a witness who was not offered until the night prior and testified that day. And I think my objection was overruled, to make it clear.
I think the objection to, I think also you agreed that the testimony, if I remember correctly, you agreed that the testimony was relevant. So what was overruled was striking the testimony. I believe that is your recollection of where we were procedurally?
Well, my recollection is I had suggested one alternative to sort of deal with the prejudicial element of it. I agree that it's relevant. I think anything on noise is relevant to the proceeding. My issue was more with the manner in which it came in and just trying to craft a remedy. If there needs to be one, we're in the middle of a hearing. We're trying to evaluate that to make sure that all sides are heard on it. So I am fine doing motion practice. I just want to make sure the record, since we're deviating from my initial suggested remedy, I just want to make sure my record is clear. That's all.
I would just note for the record that there was no objection to the lateness of the materials when they were produced prior to the hearings, just so that that's clear in terms of the noise study that came in when it came in, and that was one of the basis on which I decided to overrule the objection, because the material had come in and it wasn't objected to. Nothing was raised prior. Given that the EFSB -14 is withdrawn, and we will take a break for lunch. My clock right now on the computer says 11:54. I'm going to give everybody a little bit of extra time. Why don't we come back at 1:05? That gives us an extra 10 minutes, then, just so people can reorient and get situated so that we can begin to close down the hearings.
Thank you, Mr. Presiding Officer.
Okay. We have about 3 more minutes before everybody's back.
Can you hear us here?
Yep.
Good.
Hopefully some of you got out for lunch. It was it's a nice day out there.
Nice. And hopefully this holds for trick or treating later this evening, right?
Well, for the kids, yeah.
Well, I was going to ask Brian, what are you going as?
I will probably go as myself with an adult beverage hidden somewhere.
It sounds like my neighborhood.
Yeah.
There's treats for the adults too in my neighborhood.
The best kind of neighborhood.
Oh darn, we're on YouTube. I think I'll be quiet.
I was tempted to wear a mask for this one, just for fun.
Okay, so what do we have here? Still have another minute. We have, all right. Back on the record. We have all counsel here and two witnesses. I don't know why I'm getting feedback. Let's try this again. Okay, I think the feedback issue has been taken care of. All right, so we're going to pick up with the objection to the record request that I took under advisement. Did counsel have an opportunity to discuss this during the lunch break?
We did. Yeah.
And did you come to a resolution?
We did. Attorney Kaplan suggested, so I'll let him speak to it that way. I don't misstate it.
So I believe what Mr. Bertram and I agreed to is that we have no objection to Mr. Pachowski reviewing the HMA and the ERP and writing any comments that he has on those two documents.
That's consistent with my understanding.
Okay, so that will be RR STPB -2. And that's per agreement of the parties. And the objection's withdrawn, I'm assuming, correct?
Correct.
Okay. All right, with that, I'll ask if any of the parties have any further questions for the witnesses, Mr. Pachowski or Mr. Hinckley.
The company does not.
I do not, Mr. Presiding Officer.
And the setting board does not either. I'd like to thank Mr. Pachowski and Mr. Hinckley for their testimony today. And we can release you if you do not want to stick around for the rest of what we have to do here. Thank you.
Okay, thank you. Have a good day and happy Halloween.
Thanks,
Sam.
all. Bye-bye.
Okay, with that, I'm going to move to admit the exhibit list in whole as into the record. Do I have any objections from council?
None from the company.
None from the intervener.
So the exhibit
Eversource
list.
has none. No, I just said Eversource has none.
Okay, thank you. So the exhibit list is admitted into the proceeding as a whole. If you would like, we can go off record now and discuss next steps in terms of the schedule. And then we'll come back on the record when we've finished discussing the schedule, in particular for the record requests and briefing schedule. That's what I'd like to address now. So we'll go off record, finalize those details, and then come back on and put it on the record. Currently, what we have scheduled is we have the 8th for record requests on the schedule that we put out earlier. I'm anticipating that some of the requests, such as for noise, for the noise study, and some of the other requests may take longer, and I'd like the input from the company and Save the Pine Barrens as to, you know, whether or not we need to consider the date of the 8th too short or extended, or, you know, what are your thoughts?
I can say that if
So,
an extension, I don't have any objection to that in principle.
I prefer to keep to the schedule that we have. I think it's important that we stay on track to make sure that if we're going to have an approval, we have one in a timely manner, as timely as possible. So I think that the only of the record requests that were asked, I believe the only one that might take some time was the noise study. And I anticipate that we would have a response to the noise study by November 8th. I was concerned about having a response to the noise study within what I thought was 5 days, but as Kuthan correctly pointed out to me that was not the case. It is not due in 5 days. So I was relieved, and we have no problem. We should be able to meet that November 8th date.
Okay, so we'll leave that as November 8th for the record requests. With regard to any review by Save the Pine Barrens, Mr. Bertram, I'm going to give the interveners 5 days to review the record requests. And if you require any further process for good cause, submit your motion within 5 days. And then I'm going to give Cranberry Point a 3-day response window from the time that we receive the any motion, if any are produced by Save the Pine Barrens.
Is that going to delay the briefing schedule in your mind?
We haven't, well, for now, we haven't solidified the briefing schedule. We'll discuss that next. I just want to make sure that I don't extend out any time, because it seems to me from the discussions that we've had that Mr. Bertram may want to review and may request further information regarding noise. And if that's the case, we need it in a motion form, and I'd like a response within a certain time. I don't want to have it going out weeks. I'd rather have it sooner than later.
Okay.
I think, Mr. Kaplan, I think we're going to set a briefing schedule here and now.
Yeah.
And if something comes in from Save the Pine Barrens, you know, that the presiding officer allows, then we would have to deal with the briefing schedule at that time.
Perfect. Thank you, Ms. Evans.
And if I could too, I'm not looking to delay the briefing schedule necessarily. If something came in or we had to deviate at that point, we could also be open to supplemental submissions on a narrow issue. But I'm
Okay.
not looking to delay our initial or reply briefs.
That's fine. All right, so let me just take a look at the hearing schedule again. Or the schedule that we have.
I'm told that we had November 22nd and December as initial briefs, then December 13th as reply briefs.
Andre, I think that's correct. Oh, we have two Andres. You're on mute.
I don't know what
Which
just
one?
happened. My apologies. It's a good thing we're off the record. Bad thing we're still on YouTube. I have no idea what happened. Can everybody see and hear me?
Yes.
At least this me. Great. Thank you. Sorry.
It's Halloween.
Yeah, it's I don't know what it is. Anyways, I was looking for the date, but I'm not going to go off this screen again just in case that happens. So anybody who has the original schedule up on the computer, what do we have?
So it's November 22nd for initial briefs and December 13th for reply briefs.
Does anybody have any objections to those dates? Do we need to move those, you think, for any reason?
We agreed to them before, so no objection here.
Okay. So I think that takes care of everything we need. Does anybody have any other issues that we need to discuss regarding the schedule?
Sorry. I missed you. Sorry, we were. So can you just tell me the dates of, so the record requests are due the 8th. Mr. Bertram's, anything he's got in terms of a motion is due when?
We'll say 5 days. If we're going 5 business days, that would be Monday, the 7th of November.
14th.
Say again?
I think it's 14th. You're looking for
No,
5
no.
days after the 8th, right?
No. Five. Well, yeah, sorry. You're right. 5 days after. I'm counting 5 days from today. So that would be the 14th.
Okay.
And which would then give you till the end of the day on the 17th, Mr. Kaplan.
Just to respond to the motion.
Just to respond to, yes.
Okay.
To the extent that Mr. Bertram has something for you and that you need to work out timing, to the extent that the two of you discuss it ahead of time, that's helpful. Again, as you have you done on a number of matters here today.
Yes, Mr. Bertram's been very easy to work with, so I'm sure we can do that. I'm wondering, why would we need a motion? So Mr. Connolly is reminding me that if the company is, if Save the Pine Barrens is going to be responding to our record request on the 8th, can we also have, what was it, 5 days? Can we also have the same 5 days to respond if needed?
Well, the response that we're looking for from Save the Pine Barrens is for further process.
I understand.
Yeah.
Okay.
So it won't be an argument or.
I got it. Thanks for the clarification.
Yeah,
We had too many conversations going on, so I apologize.
no, it's fine. I just want to make that clear. So if this is their request to, reopen, a portion of the hearings for something specific with good cause, and then
Right.
then you have
And
a,
I'm presuming, right, and the company can do that as well if need be, and then Mr. Bertram would have the same amount of time to respond to our
If-
motion of that.
yeah, if something glaring came up that looked like it needed to be addressed in that fashion, then yeah.
And
I'm not anticipating that.
can I further just make sure it's clarified? So the request for having more time, more process would be in response to something that came in on record request, right? That's what we're talking about.
Yes.
I think Mr. Bertram was concerned about the noise study, was my understanding, but
Well, there's certain things that are coming in on record request, and there was actual testimony from the witness as well, but I don't know that we need an extended discussion. I mean, I'll make sure to write a motion that is very clear about what I'm asking for and why I'm asking for it. And, to the extent that Attorney Kaplan needs a response, he'll get it, and we can sort of dispense with it at that point. I feel like we're talking a little bit in hypotheticals, so.
Yeah, we are. Yeah, well, pending a motion, we have nothing to actually look at. So, okay, I think that covers everything. So, the 14th for your motion, if there's going to be any on further process. The 17th for any response from Cranberry Point. And then we'll go into the dates for the record request. So with that, we'll go back on the record unless somebody else has does anybody else have anything on this issue further? Nope. Okay. All right, so back on the record. After conferring with counsel, we have decided on the following dates. Save the Pine Barrens. We'll have until November 14th to submit any motions for additional process. And the company will have until November 17th for their response to any motion that may be filed. Record requests are due on November 8th. Briefs. The initial brief will be November 22nd. With reply briefs due December 13th. With that, we will close the hearings. I'd like to thank everybody for your participation. Thank counsel for all parties for making this process smooth. And I wish everybody a happy Halloween and enjoy the rest of your day.
Thank you too, Mr. Presiding Officer, and thank you, members of the board.